I just want to pose the question to you all participating in this session, whether after I show you the next slide and the view of the interplay of codes and conduct and the monitoring body according to the Austrian DPA, which of course is similar to the approach of the European Data Protection Board. I'm very interested in your opinion, whether you see that it's pretty easy to develop codes of conduct, to bring them into operation, and whether this is really something that is encouraged. In Austria, we first of all need an association which is deciding to file an application for the approval of a code of conduct with the Austrian Data Protection Authority. The Austrian Data Protection Authority approves the code of conduct only with a condition precedent at first. The condition precedent actually is connected to the existence of a monitoring body, which actually needs to apply for accreditation with the Austrian Data Protection Authority in relation to the supervision of a particular approved code of conduct. You can see that there is kind of coming up a chicken-egg problem, as we call it, in Austria. Next is that also the particular association owning the approved code of conduct needs to give its sanctus to the monitoring body, saying that it is fine with a particular monitoring body filing for accreditation, supervises and controls actually compliance of members of that association with the monitoring body. Here, I think there is the idea behind that there should always be only one monitoring body per code of conduct, whereas actually I think it was the idea of the GDPR that you can also have more monitoring bodies also competing against each other when supervising a code of conduct of an association. In Austria, for example, we also have 3 monitoring bodies supervising the code of conducts for accountants. If you have the sanctus and fulfill all other criteria, the Austrian Data Protection Authority issues a certificate of accreditation, and then it's possible for controllers and processors of that particular sector in which the code has been approved to apply for participation with the code owner. If the code owner accepts, a controller or processor may conclude contracts with the monitoring body, which then can do the conformity assessment, examinations, supervisions, and also the complaint management. I think it's necessary to emphasize in this regard that a controller or processor should not be able to profit actually from the advantages of compliance with the code of conduct under the GDPR, as long as there has not been a conformity assessment in which he demonstrated that he can really comply with the regulations of the code. All that done, actually, a data subject still can file a complaint with the monitoring body as well as with the DPA. So having a monitoring body, having a code of conduct does not prevent data subjects from also going to the Data Protection Authority in case he or she thinks that a particular controller is not in compliance with the code of conduct, although pretending to be such. This is the actual situation that we are now facing in relation to the interplay between codes of conducts and the monitoring body. Let me now, in the second part, quickly jump in to the smart metering code of conduct that we have in Austria. Here, the background and also the idea of having a code of conduct actually is in connection with the legal landscape that electricity network operators were confronted with when they were forced to introduce smart meters in Austria. It's actually the goal in Austria to have 95% of Austrian households connected with a smart meter to the electricity network. We have here regulations in the energy law on the one hand, and on the other hand, for sure, according to data protection law, regulating the processing of smart meter data, of very, very detailed energy consumption data. Actually, in Austria, the measurement takes place all 15 minutes with such smart meters. Moreover, actually, in energy law, we do not only have the Energy Act containing respective regulations, but also 3 regulations under this act, deriving from 2 different institutions, from the regulator as well as from the Ministry of Economic Affairs, which are regulating processing of smart meter data. These regulations contain a lot of obligations for network operators, and network operators just wanted to have a single regulation which they can actually look at when they want to know how they can legitimately and permissibly process smart meter data. And this is actually the goal of that code of conduct. This is what he is meant to be. It took some discussions actually in order to persuade the Austrian Data Protection Authority that this can be actually made topic of such a code of conduct under the GDPR. For sure, the Data Protection Authority now had to go into the details of energy law in order to understand if the regulations of the code of conduct are in compliance with the GDPR.